The person who broke the rules big time was Theresa May by appointing Liz Truss, who plainly was evidently not up to the job. I think she broke the law, as it happens, Theresa May, in appointing Liz Truss. She was evidently not qualified by experience, nor by qualification. It's to Theresa May's discredit that she even thought that she could be appointed to that job. The judges were absolutely furious, and they immediately became oppositional. A retired law lord who was absolutely stupefyingly rude every time I saw him. He would say you were destroying the judiciary as he knew it. I was betraying my position as a member of the bar. I was ruining a justice system that had lasted for 2,000 years.
You're listening to the Lord Chancellors, where politics meets justice, brought to you by the University of Law. I'm Frances Gibb. This week I'm speaking with Lord Falconer. Charlie Falconer, Lord Falconer, was Lord Chancellor under Tony Blair. He was the first holder of the new style position which combined Lord Chancellor with being Justice Secretary as part of far-reaching constitutional reforms in 2005. Falconer knew Blair, they'd been flatmates, and the Prime Minister brought him in to the new Labour government of 1997. It was the start of a radical upheaval. A new Department of Constitutional Affairs was created under Falconer, replacing the old Lord Chancellor's department. The idea had been to abolish the ancient role of Lord Chancellor, but it couldn't easily be done, holding, as it did, a key place in the unwritten constitution. So, a new Ministry of Justice was created. This combined the old Lord Chancellor's responsibilities for courts and legal aid with prisons, formerly under the Home Office. And in 1997, Charlie Falconer became the first holder of this new combined post. The changes were highly controversial, not least with Falconer's predecessor, Derry Irvine, who strongly opposed them, only to find himself sacked. But Falconer was not long in his new post. Within months, Tony Blair had handed over his role as Prime Minister to Gordon Brown, and Falconer was replaced by Jack Straw. I began by asking Lord Falconer what he thought of the present state of the justice system. I'd like to start off because we are here some 20 years almost from when you were really actively involved in the justice system, although you've done a lot since. It's in a state of crisis, isn't it? How do you find it?
Yes, it is in a state of crisis. And what happened was there were very fundamental reforms to the way that the justice system was organised between 2003 and 2007. And then almost immediately, the financial crisis struck. And the period since 2008 or 9 within the justice system has been a period where if you talk to anybody, judges, lawyers, anybody who's got anything to do with the public provision of justice, it's got worse and worse and worse. So yes, the justice system is in crisis. But the question is it a crisis caused by the absence of proper resourcing, or are there other reasons? I mean, I think for a whole variety of reasons, the constitutional position of the justice system, and in particular the independence of the judges, is now very much stronger than it was as a result of those constitutional changes.
Well, do you? That's interesting. I'd like to ask you about that because obviously you were right at the heart of it. So going back at the beginning when you came into it all, can you just explain briefly how you got into the role of Lord Chancellor? It wasn't your first job.
No, I became the Solicitor General in 1997. Between 1998, after I ceased to be Solicitor General, and 2003, I held a number of other ministerial posts. I was Minister of Housing, I was Minister of Criminal Justice in the Home Office, I was Minister in the Cabinet Office. But then in 2003, I became the Lord Chancellor, effectively there to make very substantial changes to the structure of the justice system, and in particular, how the judiciary related to the executive, what the final court of appeal should consist of, and also how judges were appointed.
They were very, very far-reaching and fundamental reforms, and they caused a lot of grief and trouble amongst the judiciary. How much were you personally behind those new ideas, which substantially changed things?
I was very, very strongly behind them. There was lots and lots of people who had been involved in how they would actually be formulated, and in particular Andrew Adonis, who was then the head of the policy unit in Number 10, was somebody who I had talked to them about before. Hayden Phillips, who was the permanent secretary at the time in the Justice Department, was also involved in the crafting of the overall structure. And I'm talking now about the period building up to, as it were, my appointment as Lord Chancellor, which occurs in June 2003.
Were they your ideas? I mean, for example, to remove the Lord Chancellor as being head of the judiciary, was that your idea?
It was a collective effort. It was not. I would not for one moment claim that the whole structure was my ideas, but I was strongly in favour and part of a group that was pushing for those ideas.
For people who may not remember, what was wrong with the system as it was? What was the key difference that the changes sought to make?
There were three key things. First, you had to remove the head of the judiciary from the executive government. It was completely wrong that the head of the judiciary and the person who presided over the final court of appeal was a member of the cabinet, when the most common litigant in the final court of appeal by 2003 was the government itself. It just was completely unsustainable. Secondly, and separately, you couldn't have the executive, the politicians, appointing all of the judges, because if they could appoint every single one of the judges without restraint, they could appoint people who favoured them. And you saw the risk in relation to that when Boris Johnson is done down by the final court of appeal on the prorogation of Parliament. He says, it's obvious that these judges are political. I should become more political in my appointment of judges. Can you imagine if now, when you're about to appoint the Lord Chief Justice, the Prime Minister can interview them and decide the one that is most favourable?
You're saying how much worse it could have been, but in fact it wasn't. The system worked quite well, didn't it?
The
old system I'm talking about.
The old system worked incredibly well because the recent Lord Chancellors, myself, Lord Irvine, Lord Mackay, were fastidious in appointing on merit. But what would have happened if you'd ended up with a Prime Minister like Boris Johnson? As the tensions between law and the executive got stronger, he would just appoint a Lord Chancellor to
do his bidding.
To do his bidding. And the Lord Chancellor is completely an appointment, or it still is, but even more so prior to the changes, was a appointment of the Prime Minister. And if he wanted executive-minded judges, then he could have just appointed a toady as the Lord Chancellor.
Yes, I mean, it is still a political appointment, but of course not in charge of appointing judges.
Exactly. Well, he's sort of in charge of appointing judges, but he can only appoint people whom a Judicial Appointments Commission recommends for appointment. Exactly. So, and the third one is the Final Court of Appeal was a committee in the House of Lords, and the law lords, very impressive individuals, scurried around Parliament as a minor part of what happened in Parliament, and they needed their own separate institutional base.
I want you to cast your mind back to how it was having to tell the judges about these proposed changes and what their reaction was.
I remember they discovered, because at the time I was appointed Lord Chancellor, the changes, I mean, it was the abolition of the role of Lord Chancellor, in particular being head of the judiciary, the creation of a Supreme Court, and the creation of a Judicial Appointments Commission. They discovered it by the press release which accompanied my appointment. So they were outraged, in my view quite legitimately, that these massive changes were being announced by a press release rather than after some detailed process.
Because they weren't informed, were they?
They were not informed at all. And the first they heard about it, as it were, from somebody involved. Was I had a telephone conversation with them. They were at some judicial away day, all the heads of, and they were furious. They were angry. They were outraged that they hadn't been consulted, and they immediately became oppositional to the thing.
But they should have been consulted.
Of course, they should have been consulted.
It was quite wrong. Why weren't they?
Well, as it happens, I think the reason they weren't consulted was because a view was taken, I have to say not by me, that unless you absolutely went straight for it, it would never happen or never happen within living memory.
Did it become very personal? I mean...
No, Harry Wolff, who was the Lord Chief Justice at the time, we occasionally had friction, but he's basically a very warm, pleasant man, and it was very difficult really to fall out with him. He was personally kind and pleasant, but there was absolutely no doubt that the judges were absolutely furious. And Harry was nice, but there were other judges who were incredibly angry. I remember, for example, Lord Chancellor, who was then a retired law lord, who was absolutely stupefyingly rude repeatedly every time I saw him. The comfort...
What kind of thing did he say?
He would say you were destroying the judiciary as he knew it. I was betraying my position as a member of the bar. I was ruining a justice system that had lasted for 2,000 years. He was absolutely appalling. And I got comfort in relation to that from James Mackay, who was my predecessor, but two, because before me had been Lord Irvine, and before me had been Lord Mackay, a very highly respected Lord Chancellor. And he had been the subject of the same degree of vituperation from Lord Chancellor and from the then Lord Chief Justice, Lord Lane. And his proposal, for which he got vituperative abuse, was that he wanted solicitors to have rights of audience in the higher courts of England and Wales, which was a perfectly reasonable suggestion. And the consequence of that was that Lord Lane compared him to Nazis, and Lord Chancellor and other judges wouldn't speak either to Lord Mackay or to his wife.
I think they turned their back on him at dinners and things like that. But I do remember a particular dinner, a judge's dinner at the Guildhall, where I think you were slow hand-clapped. You were speaking. Do you remember that?
I don't remember being slow hand-clapped, but
I think you were.
I remember a lot of hostility.
There was. So was Tony Blair completely behind what?
He was very, very supportive.
Or did he begin to doubt, because having come from, you were both lawyers, obviously.
No, he didn't. He didn't begin to doubt it. He was complete. I mean, I had his support throughout it, and the consequence of that was, although there was a very torrid process in Parliament, it lasted 2 years from 2003, when the changes were announced, to 2005, when they eventually passed through Parliament, and that was because the Lords resisted them repeatedly. But they got through in the end because there was very strong political support for this change.
How did you get on with Derry Irvine? Because he was moved aside for you to take on the new job.
He was...
Is that correct?
He was, that's correct. I replaced him.
You replaced
moved
him.
aside. I mean, he went and I came in. He was personally polite to me and okay with me, but he was absolutely furious about both being removed as Lord Chancellor and the constitutional changes that were being introduced. He was very, very against them.
I don't think he's ever got over it, has he?
Well, I think he remains angry about what happened.
He never kind of carried on in public life.
I think that's right.
How much of a surprise was the reaction to you? Because, of course, you were not a politician. That wasn't your background. You'd come from the bar, and you'd come in because you'd been handpicked as a close friend of Tony Blair, famously his flatmate.
Yes.
So it was a very different background, and suddenly you were thrust into this maelstrom of politics and turbulence and so on, and hostility. How did you find it? Was that reaction a surprise to you?
The intensity of it was a surprise, though it shouldn't have been a surprise. And that was the intensity of the surprise was, as it were, a failure of my political antennae. The judges were very, very hostile to me for doing it because they thought I wasn't a politician and they thought I was treacherous in introducing this without telling them. So they were very, very angry.
You'd been a traitor to the legal profession.
Precisely. Really. That's exactly what they thought. And they thought, how could you have done this to us?
Did you feel you had?
No, not at all.
Had been a traitor?
Not remotely, no.
You've never had any regrets about doing it?
I've had
or
no
anxieties about doing it?
Well, it was a very anxious making process because they were so hostile for so long in relation to it.
So a very stressful time. Really.
A very, very stressful time. My wife was a barrister as well. My brother-in-law was a barrister. I came completely from the legal fraternity. I'm a creature of the law. My father is a lawyer. My grandfather is a lawyer.
And everybody's normally quite polite, or if they're rude, it's couched in polite terms.
Exactly. And they were unalloyed in their opposition, and they were personal about the whole thing. So it was a difficult time. I do not regret for one moment having done it, because my strong feeling about that period, 2003 to 2005, was it was a fundamental reform of all of the institutional aspects of the justice system, how you appoint judges, what's the final court of appeal, who's the head of the judiciary, how it fits in to the executive, how you ensure independence. Those things had to be done, and I am incredibly proud of having gone through them, because the legal profession, and in particular the judiciary, are essentially conservative, and without it having been done in a confrontational manner, because that's how it was done ultimately, it would never have been done.
Looking back, you've had time now, we've all had time to see how well it's worked or otherwise, and some people do regret some aspects of it, and we'll come back to judicial appointments, but what do you think? Do you think it's worked? Do you think the reforms have been a success?
I think the reforms have been a profound success. I think they've also been a profound guardian of the independence of the judiciary. I feel very, very strongly that irrespective of these reforms, frictions which you see right across the world between executives and judges would inevitably in this country have got stronger and stronger without providing institutional protection for the final court of appeal and for the appointment of judges, and to ensure that there was a proper justice minister as well as a proper judicial head of the judiciary. We would have been in a very, very bad place indeed.
Critics say the Lord Chancellor's position has been weakened by the reforms, and thereby the judge's position has been weakened because they don't have somebody standing up in cabinet in the way they used to. Is that true? I mean, are the judges weaker than they were? They don't have that
I think the judges are so much stronger than they were, because they have this institutional independence now, which they didn't have before. The Lord Chancellor should definitely stand up for the judges in government, and in particular stop any attacks on the judges. And Liz Truss, when she was the Lord Chancellor, she was a useless Lord Chancellor in every single respect. And how the Conservative Party failed to spot that she was useless at that, she'd be useless at the Prime Minister, that's by the by. She should have responded much more quickly than she did. But I don't think the fact that she didn't respond until the end of the week rather than the beginning of the week, which is an important delay, in any way undermined the standing of the judges. I think what was problematic for the judges at that particular time was not the ridiculous Liz Truss's failure to respond. It was the sense that the judges are now much more in play as a part of the Constitution. So many people think the judges are, and I don't think this, but many people think they're a part of a Remainer elite trying to frustrate the views of Brexit. That's nothing to do with the reforms. It's all to do with the tensions that are present everywhere in Europe and in America, where the judges are a part of the state, which people alienated from the state, for example, very many people who voted for Brexit, take issue with. Had Had we not provided institutional protection for the judges, meant that the state just couldn't appoint them as they wanted, as was the position before the changes, separated the Supreme Court, made it identifiably separate from Parliament, made the head of the judges a true judge, not a politician. Had we not done that, then the pressures on the judges would have become pretty heavy.
So the reforms did work in entrenching the independence of the judiciary.
Very much
so. Better for the judges, but what about the position of Lord Chancellor?
Well, he or she becomes a completely different creature. I mean, he no longer is the Lord Chancellor, the leader of the judges, and hopefully a massive legal figure as well as a political figure.
Well, they're career politicians, aren't they? And they're there for 5 minutes and then they move on.
They generally, in the last 50 years or 60 years, were career politicians. If you look at Kilmuir, Manningham Buller, Elwyn Jones, Hailsham, they were career Havers. They were all career politicians. It's the first non-career politician who becomes the Lord Chancellor in modern times is Mackay.
Finally, on the changes and the impact they've had, one of the changes was, of course, that they don't have to be a lawyer. Some people think that should be restored. Does it matter that they're not lawyers?
I think that the truth is that the absolutely worst Lord Chancellors, Grayling and Truss, were not lawyers. I think some of those who have been good, Gove and Liddington, equally were not lawyers. My own view is you should not restrict it to lawyers, because you then restrict the choice and remove from yourself people who would be good. The attempt that we put into the Act of Parliament to try to avoid people who didn't understand the importance of the rule of law was to say, and this is the only cabinet appointment that has this, there are conditions that have to be satisfied for the Prime Minister to appoint somebody to be the Lord Chancellor. You've got to be qualified either by qualification as a lawyer or by experience. For example, you've proved yourself to be a constitutionally strong figure. You've got to satisfy one or other of those requirements before you can be appointed Lord Chancellor.
And the other thing people say, looking back at the reforms, they'd like a Lord Chancellor with constitutional responsibilities separate from the Justice Secretary. Is that something you would favour?
Well, when you say, I mean, I think there should be somebody...
A senior person, maybe in the House of Lords, who does not also run the Justice Department.
A sort of constitutional watchdog.
Yeah.
But you've got the Attorney General who requires compliance with the law, a separate freestanding constitutional person.
I think Lord Burnett wants this.
Yes,
reinstate
I just don't think there's any realism in that, because ultimately, what would this person do? How would he be appointed, and what authority would he have? The reason why the Lord Chancellor had authority was because he was the head of the judges, and for all the reasons we've gone through, that couldn't continue. To have somebody without that authority would become very confused with the role of the Attorney General. The key thing on the rule of law within government is that the government complies with the law, and that is the role of the Attorney General to ensure.
What about the recent incumbents we've had? We've had, first of all, the brevity of their tenure.
Yeah.
We've had people who are not regarded necessarily by the judiciary. I don't know whether you think that matters. And have we had people who are up to defending the rule of law? Do they understand it?
We have had two who are conspicuously useless, which is Liz Truss and Chris Grayling. I do not think Michael Gove, David Liddington, Ken Clarke, Jack Straw, Shabana Mahmood, or Alex Chalk, I think all of them understood the importance of the rule of law, and I think all of them, David Gauke as well, all of them were good Lord Chancellors doing that. I think, as it happens, Alex Chalk was doing his best in an atmosphere that was terrible. But he was basically being forced by a broken government to sort of swallow his principles on a regular basis. But be under no illusions, and I say this as a lawyer, if the Prime Minister wanted a lawyer to do the job who was amenable, he or she would have been able to find one. You will recall when the aforementioned Kilmuir is sacked, he complains to the Prime Minister, Macmillan, that he was given less notice of his sacking than his cook would have been given. And Macmillan replies, cooks are a lot harder to find than Lord Chancellors.
Perhaps we can look now to the future and the relationship and how it might change or not between judges and ministers. You've touched on the role of the Lord Chancellor, whether they should be a lawyer or not. I think you've answered that, and I think you wouldn't go back on it. Are there things you would go back on?
I mean, the one thing that I think one needs to look at is this sense of the fact that the appointment of the Lord Chancellor should properly reflect somebody who's got the wherewithal to stand up for the values of the law within government. And we put in various provisions in the Act which made the Lord Chancellor's appointment unique, namely the Prime Minister had to think whether or not this person did it. I mean, and in a sense, Gordon Brown appointed Jack Straw, who's a very, very big figure in government. David Cameron appointed Ken Clarke, who's a very, very big figure. Both people well equipped to do the job. The person who broke the rules big time was Theresa May by appointing Liz Truss, who plainly was evidently not up to the job. And I think she broke the law, as it happens, Theresa May, in appointing Liz Truss, because she was evidently not qualified by experience nor by qualification.
And is that as though you're saying that breaches the terms of the
Constitutional Reform Act?
Yes, yes.
One should have made much, much more of a thing.
She could have been challenged on it.
She could have been challenged. I mean, I suspect the courts would have been very reluctant to interfere, and I suspect the courts would have said, actually, this is a political matter that should be enforced by politics. Now, having seen the way that Liz Truss was as Lord Chancellor, and as it happens, seen the way that she was as Prime Minister, she was patently not up to the job, and it's to Theresa May's discredit that she even thought that she could be appointed to that job.
And getting them to swear an oath has been recommended by the Constitution Committee, which you sit on.
Yes. They do.
They do.
And the oath is in the Constitutional Reform Act, and it's an oath to uphold the independence of the judges and a properly functioning justice system.
Would it make any difference if the oath was bolstered?
Well, I think we had a debate about this in the Constitutional Committee when I was there. I was strongly in favour of bolstering it on the basis that you should treat most politicians as responsible people. If they swear an oath, then hopefully they will comply with it. I mean, many might not, but I think some would, and there's no harm in doing it. It also would provide a filter through which judicial reviews could be held. If you've promised to do this, and that oath is in an Act of Parliament, then if what a Lord Chancellor is doing is patently at odds with the oath, then that would be a reason to suggest that what the Lord Chancellor is doing is unlawful.
What about the attitude we've had in recent administrations to the rule of law? I suppose Boris Johnson's the obvious example. But I mean, does that show that ministers are increasingly have a disregard for the importance of it? And what does that mean for the relationship between judges and ministers? It puts them immediately at loggerheads.
It does. And I mean, the most striking example of that was the Rwanda Act, which was passed, where in effect the government, which had a majority in both houses, procured Parliament to pass an Act of Parliament that overturned the finding of fact by the judiciary that Rwanda was a safe country. And that was absolutely interfering with the separation between the courts that make judgments on the facts and the executive that can change policy. This was not a change of policy. This was saying we don't like what the courts have said, so we'll just overturn it by an Act of Parliament.
So the reforms that came into place in that sense have not stopped that kind of manoeuvre.
Quite the reverse. They have protected the judges because the consequence of the reforms made it impossible for the executive to pack the courts with people they thought would be amenable. And I go back to the example I gave. After the prorogation case, Boris Johnson, supported by his then Attorney General, Geoffrey Cox, said there should be more political input into the appointment of judges. After the prorogation case, it came for the state to appoint a new Lady Chief Justice, and happily there was no question of the Lord Chancellor, driven by the Prime Minister, interfering and seeking the most deferential judge to become the Lady Chief Justice, because that had all been offshored from the executive.
Another thing which seems unprecedented is the quashing of all the convictions of the sub-postmasters.
I was strongly in favour of that.
Were you?
Yes, and I think I was in favour of it because I don't think, and I have no complaint that the judges failed to spot what had happened, because they were dependent upon the evidence produced to them. But we ended up in a situation where very significant numbers of the sub-postmasters would not cooperate with any judicial process because it had let them down so badly. Senior judges, in particular Lord Burnett, put forward a scheme. He was the retired Lord Chief Justice. He put forward a scheme and said, well, even if they wouldn't agree to appeal out of time or go to the Criminal Cases Review Commission, the Lord Chancellor or the Attorney General could have referred their cases to the Court of Appeal, who could have quashed them. You couldn't effectively have an appeal that could properly be run if the person on whose behalf, who was still alive, who was making it, wasn't cooperating. And they weren't cooperating, quite understandably, because of the way the justice system had treated them overall. This was the only method, in my view, by which it could effectively be done, and it was the right thing to do.
So it did not amount to an unconstitutional or a moving of the constitutional boundaries, put it that way.
Not at all, no. And indeed, one should recognise that from time to time, the executive and the judiciary do have to cooperate in order to achieve particular things. For example, in relation to the funding of the courts, for example, in relation to the maintenance of a system to appoint the judges, for example, to deal with miscarriages of justice that cannot be dealt with in the ordinary course of business by the courts. And exceptionally, very exceptionally, the Horizon Post Office scandal was one of those.
We've now got a Labour administration and a lawyer at the helm, as in the time when you were there with Tony Blair. What are the flashpoints, do you think? There's still this funding crisis we spoke about at the beginning.
I think that there will constantly be a tension about funding, in my view, because the courts have fallen so far behind, and there is a mismatch between the legitimate desire of the judges and those who work in the justice system to have a much better funded justice system, and the political priorities of the government. But that is a fundamental tension between the court system and, as it were, the politicians. And the key thing to do in relation to that is to ensure that the independence of the judges is not affected by that debate. And I think that reforms did that. The other area of tension, and it is a permanent tension, is the extent to which the courts are willing to interfere with decisions made by the executive. So I don't know if you remember the Belmarsh case, where a statute of a Labour government which allowed the state, in the wake of 9/11, to lock up foreign nationals was declared incompatible with the Human Rights Act by the House of Lords, sitting with 11 members. It was a very substantial court, presided over by Lord Bingham, a very unpolitical, highly respected judge. The Labour government then changed the law in response to that. Fast forward to the Supreme Court, presided over by Lord Reid, also a very highly respected lawyer. They refused to interfere in something called the two-child rule, which is an act of parliament that says if you've got more than two children, you can't get benefit for those children over two. Everybody agrees that's discriminatory, in the sense that single women have to look after more than 2 children, more than men do. But the Supreme Court, in response to an attack saying that's also in breach of the Human Rights Act, say we're not interfering, because if Parliament has decided that there should be a 2-child rule, that's for them to decide, not for us. The willingness of the judges to interfere in executive decision-making is, in a sense, a constant decision that they've got to take, and the extent to which they are willing to interfere seems to me to depend to some extent on the tensions between the executive and the judiciary, which in its turn depends upon the extent to which the judiciary think they would be pushing it too far in a popular sense. And
so it relies on a subjective test at the time, relationship between the two.
Exactly. And it is incredibly important when the judges are conscious of that they should be completely free from any interference as to who is appointed to their midst. And that's why I think the changes are incredibly important to insulate them from what is a much more questioning attitude amongst the public as to the role of the judges.
The appointments are free of politics, although some would say, and I've heard you say this, that it's a challenge for the judges because they are perceived to be, and you mentioned it earlier, a sort of pro-Remainer kind of elite. Is that something, do you think it's true? And how can it be combated by them?
No, I don't think it's true. I think they are absolutely fastidious, the judges, in doing the law in accordance with the law, because I think they're incredibly aware that the strength of the whole state in part depends upon having a genuinely independent judiciary that is famous for doing the law and not doing politics. But I don't think that is the view necessarily of all of the electorate, and it is certainly not the view of some exploitative politicians. And you will find, as time goes on, particularly, for example, in relation to the immigration debate, where the Prime Minister, the Home Secretary, criticised the lefty lawyers for preventing or frustrating a whole range of changes they wanted to make to immigration. And that inevitably, as was explicit in the prorogation case, would lead to attacks on the judiciary.
Looking at future challenges, one of the things judges criticise is the way that under the reforms that you were part of, the prisons were put in with the courts and legal aid, and the Justice Secretary, obviously they're going to always take the bigger demand and leave legal aid to one side or to suffer with the poor relation. Is that something you think should be looked at again?
No, I do not. I was really keen to get the prisons into the same department as the person who ran the courts, the person who ran legal aid funding, the person who was responsible for the policy of the law, because prisons are where the courts obviously send some people whom they convict. It's all on one coherent side of the Justice Department. The worry that the judges repeatedly put to me was, if you have prisons, because it's such a large percentage, it's going to lead to less money for the court system. And that is completely wrong. For some considerable time, long before these reforms, the Treasury had been looking at the justice system as a whole. So more money for prisons did not lead to less money for the courts. So it's a false belief on the part of the judges. The other aspect of it was, I think, the judges thought that money was being taken from the court system in year to fund the prisons. That's completely not true. The amount of money that the court system had wouldn't make them a tiny dent on the prison system. So I think those criticisms are wrong, and I think it is so much better that the department responsible for the court system, responsible for the judges, should also be responsible for the places that judges are sending prisoners. Because it's not just the prison system, it's also the probation system, it's also the youth justice system that the Justice Department is responsible for. And the Justice Department should be responsible for all of those things.
Do you think that judges should be made to take account of the capacity in prisons when sentencing?
Well, in some ways they do, because there's been various decisions that say if the prisons are very crowded and the experience of the prisoner is worse, that can lead to a shorter sentence. And I think that is legitimate. I think it is for the state to produce the prisons generally, and it is not for the judges to start making judgments about that.
But they are under pressure to do that, aren't they?
But they should not in the end, because it's for the state to do that.
So if they want to jail somebody, they should go ahead and do it, whether the space is there, apparently there or not.
Subject to that minor, and it's not a significant effect on sentencing. Yes, I think if the state, for example, is laying down minimum terms for murder, which then has the effect on affecting all the other sentences, then it's for the state to produce the prison places. And if the position is that there aren't enough prison places, then you end up with the state having to deal with it, as Shabana Mahmood found when she took over, because the previous government had not built enough prison places.
But I think they have been urged, haven't they, to go easy, if you like, on custodial sentences, or to delay the cases that may involve custody. They've been urged to do all of that. Is that right?
They have been urged by a whole variety of people to do that. Yeah. But the way the system should work, but is not working at the moment, is if we pass acts of parliament in parliament saying this is the sentence, or that's the minimum, or this is the guideline for murder, then I'm afraid the state's also got to make arrangements for prison places to be found. And if they don't, you end up with the disaster that occurred at the end of the Tory government, which is there weren't enough prison places and you had to release certain people.
There was a story not long ago that the Lady Chief Justice has been overruled in her bid for more sitting days. Is that the right decision? And why should it be? Should that be a decision for the judiciary?
Well, the judiciary cannot command indefinite amounts of money. There has always got to be a collaboration between the state and the judiciary about funding. And the idea that the judiciary should be separated from everybody else is just not realistic, basically. So ultimately, the judiciary, have got to persuade the Treasury or the Lord Chancellor to speak on the judge's behalf to the Treasury to get whatever is required. But there are limits in relation to that. And the problems that the justice system has faced over the last 20 years, or no less, from 2008, say for the last 16 years, have been to do with funding, basically. But there's not a magic monetary.
So has every other part of the public sector.
Though the problems about the funding of the justice system, and in particular the court system, is a new problem. It wasn't really a problem before about 2010, but then austerity, which really hit the courts hard, because the then Lord Chancellor, because it's the Lord Chancellor who does the negotiations on behalf of the justice system, effectively agreed to be an unprotected department and agreed to very, very substantial cuts. And there hadn't really been those substantial
cuts. Should it be a protected department, justice?
I think the state needs to realise that if we don't properly fund the justice system, we cut to the very essence of what makes the UK such a successful place. I think it should be protected, but the question of whether it's protected is a political judgment. And politically, for example, health and education figure much more prominently. And in a democracy, it is that which figures most prominently in the electorate's mind that will determine the priorities in relation to expenditure.
What advice would you give to Keir Starmer? I think he needs some good advice at the moment, don't you?
Well, I mean, not for me to give him advice. The key thing was, when we were in government, have a clear sense of direction which the public can understand. But the clear sense of direction has got to be real, in the sense that the unifying principle that the government of which I was a part had was we wished to modernise the public service and modernise the attitudes of the way that government functioned. And that principle could be applied to the things that were done in health, the things that were done in education, but also the things that were done in justice. And if you have an organising principle and are clear and stick to it, then those changes become the thing that people focus on rather than the stuff around the periphery.
Well, what can he do? I mean, we're letting out thousands of prisoners isn't good, is it? Doesn't look good.
Inevitable.
Can't build prisons overnight.
No.
So how can that be resolved?
It was an utter inevitability, because by the time, I mean, I think
You're saying it was a legacy.
Well, I would simply say Alex Chalk made public repeatedly that there was this problem and that Number 10 wouldn't do anything about it. And so that wasn't a choice on the part of the government. That was inevitability, because if you didn't let some people out of the prisons earlier than you otherwise did, you would have had nowhere to put the people who should have been coming in the front door. So it was inevitable.
Are you still involved in advising the new administration in any way behind the scenes?
I'm a strong supporter of Labour, but I'm no.
You haven't got a role.
I've got no role, no formal.
Would you like to have?
I always like to be in government, but the time has come probably to move on from that.
Did you enjoy your time when you were doing it under the Blair regime, despite all the hostility you encountered?
I mean, it was a very stressful time, but looking back professionally, it was a time where I believe that I achieved a lot, and in terms of what I was doing, namely primarily steering through these great constitutional reforms, there could be no more worthwhile task than that.
This podcast was brought to you by the University of Law. Subscribe now to make sure you don't miss the next episode.